So the Supreme Court just made it much easier for law enforcement to violate people's constitutional rights because they just, in yet another shadow docket opinion, got rid of the stay which was stopping the alleged racial profiling in Los Angeles. That's where there are these immigration raids, where the immigration task forces, ICE, would just hang out around car washes, Home Depot parking lots, where they basically targeted people that looked brown to them and maybe they thought their English wasn't so good, and that's why they went and stopped them, which violates the Constitution. There was a temporary restraining order said stop doing this. Then it made its way up to the Supreme Court, and in another shadow docket decision, no full briefing at all, the court says get rid of the stay, let the government do what it wants to do. Now, this was a per curiam decision, meaning usually reserved just for ministerial things, not a signed opinion. But there's a lot to this opinion, despite its ridiculous brevity. And what does it tell us about the presumption of regularity? What is the presumption of regularity? We're going to get into it in a moment. But first, make sure you do subscribe to us. Make us the biggest and best channel that does the intersection of law and politics. So hit that subscribe button. What is the presumption of regularity, and why am I talking about it? It's founded on this common sense idea that government officials have properly discharged their official duties. There's a presumption that they're acting in good faith. Sometimes there will be minor gaps in a proceeding related to procedural technical formalities, and by the book, a court may just say, look, I'm not going to get into motive in every single action of the government. I'm going to presume that they're acting in a regular way in good faith. Now, in practice, what that means is it ends up being a pretty friendly presumption to people who represent the government a lot of times. And what happens there is when you walk into court, or in the old days, when you walk into court as a DOJ attorney, you carry a lot of gravitas and you carry a lot of deference that's given to you because you're representing the United States. That's what we would always say. I'm Shanlin Wu on behalf of the United States. Judges respect that. They give you the benefit of the doubt with what you're talking about this. Now, why am I talking about this? Because recently there's been a lot of talk about this presumption of regularity really being destroyed by the Trump administration's DOJ's behavior. Judges are really getting fed up with these misrepresentations, sloppy representations by the government, outright contemptuous behavior like you saw when Judge Boasberg ordered the planes turned around, taking people to El Salvador, the Supermax prison there. It was ignored. Most importantly, the lower courts have been telling the DOJ attorneys that the representations are becoming questionable, and they're questioning motive. They're asking them questions about it. Another great example of the presumption going downhill is that grand juries in D.C. now have refused to indict, at last count, 7 cases in the past few weeks, including, of course, the famous Subway salami sandwich thrower. In my time as a prosecutor in D.C., in the 11 years, I saw 1 declination by a federal grand jury. So that's the difference. But these are the lower courts. The Supreme Court's conservative majority has no problems with swallowing anything that the Trump DOJ feeds it. No questions asked, eyes wide shut. No better example of that than this latest shadow docket ruling about the immigration policies and enforcement going on in California. First, let's say that it is an understatement to say they can do things more freely. It's basically just a green light to do racial profiling. The per curiam opinion, as you see, is incredibly skeletal. It says absolutely nothing. And that's very common when they are being used, in my opinion, the right way, which is about something not that important. We're letting the lower court decision stand. We're not taking the case right now. We're affirming it, period. It's not something substantive. Here you have the unusual situation, but it's been happening a lot with these shadow docket per curiams, of people dissenting and concurring to it, even though the whole idea is kind of an unwritten opinion to show everyone agrees, with what's happening. So here, Sotomayor gives a devastating, blistering dissent to this, which is important to read. But what's really significant is Justice Kavanaugh's concurrence, in which he kind of lets it all hang out. He speaks freely, explaining why he thinks it's fine. Now, he starts off on the right foot. He gives the correct standard here, saying that immigration officers may briefly detain an individual for questioning if they have a reasonable suspicion based on specific articulable facts that the person being questioned may have committed immigration violations illegally in the U.S. That's the same Fourth Amendment analysis that is used to stop anybody. There has to be reasonable, articulable facts. Now notice the shadow docket conservative majority doesn't even bother to state the standard. Okay, here's their entire opinion. Take a look at it. There's like nothing to it. Now, Kavanaugh, at least, lets it all hang out by giving us some insight into his thinking and is speaking quite freely, like he's at a speakeasy. He just dives into it. He tells us, the government estimates that at least 15 million people are in the United States illegally. Many millions illegally entered or illegally overstayed just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. About 10% of the people in the Los Angeles region are illegally in the United States, meaning about 2 million illegal immigrants out of a total population of 20 million. Not surprisingly, given those extraordinary numbers, says Justice Kavanaugh, U.S. immigration officers have prioritized immigration enforcement in the Los Angeles area. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants and those who do not speak much, if any, English. That is not, in my opinion, reasonable, specific, articulable facts about each person they encounter. That is racial profiling to a T. Second question for the justice, where are you getting these stats from? The percentages, the numbers. He does not even bother to cite to statistics. Those were quoted to him by the DOJ attorney, and here's a great example of the presumption of regularity. He just takes it on his face. If they say it, I'll use it. He does not question it. He doesn't find any reason to give any verification of these sorts of statistics. Doesn't even bother to do that. That is a remarkable indication of the way that they're actually giving far more than a presumption of regularity. They're just taking whatever the government says as gospel truth here. Now, the other problem with this shadow docket decision is, once again, it's come up on the basis of looking at a TRO, preliminary injunction, and as usual, the Supreme Court gets it asked backwards in terms of how to analyze the harm. Kavanaugh goes through this issue about harm, and once again, they say, anytime the government, meaning the executive branch, might be restricted in carrying out its duties, that's a kind of irreparable harm to the government. No, it's not. It is irreparable harm to the people whose rights may have been violated, the people who are seized, may be hurt, terrified, in violation of constitutional rights. That's irreparable harm. Why is it irreparable? Because it cannot be undone. You can't give it back to them. That's the definition of irreparable. Yet, Kavanaugh, like the rest of the conservative court, sits in their ivory tower thinking, oh, there's this conceptual notion that if you stop the government from doing something, that's irreparable harm. It's not irreparable harm. You could litigate it, you could reason it out, have it fully briefed, go through the courts of appeals, make a decision, and if it turns out that the government's actions are wrong, you could say, okay, you're wrong. And you know something? That's why we had a TRO, to make sure you weren't doing a bunch of irreparable harm based on the wrong legal actions. On the other hand, if at the end of all that fully brief process, they say, this is okay, you're doing the right thing, they can start to do that. No harm, no foul. No one's been hurt in the meantime. The uncertainty was put away because you took the time to go through the process. But that's not what they want to do. And his statements reveal the enormous arrogance of this court, as they no longer, in the persona of Justice Kavanaugh, feel a need to give statistics, feel a need to be modest in what they're saying. All right, we'll keep an eye on this one, but we know what direction it's going in, and we'll talk to you soon.
I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm. dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak firm, fighting for your justice every step of the way.